Good afternoon, ladies and gentlemen, and welcome to the Election Compliance Audit Committee meeting. We have a quorum, and so we may begin. Member O'Callaghan has sent his regrets, so we will be operating with the 4 members. Are there any declarations of interest by the members? Seeing none, thank you. Are the minutes for the December the 6th Election Compliance Audit Committee confirmed? Yep. All in favor? They're unanimously confirmed. Thank you. Before considering the contributor report that is before us today, I would like to make a brief statement. As required by Section 8834 of the Municipal Election Act, the City Clerk has reviewed contributions made to candidates and registered third-party advertisers and has prepared reports outlining any apparent over-contributions by contributors. To assist the Clerk in carrying out this legislative duty, the Clerk has retained an auditor to review the contributions and report his observations. The Clerk's auditor has now completed his review, and the Clerk has prepared 6 contributor reports. Those reports were submitted to the committee for its consideration on December the 6th, 2019. The committee deferred consideration of 1 report relating to John Riddell to today's meeting at the request of Mr. Riddell's counsel. The committee will consider today the deferred report and will decide whether to commence legal proceedings against a contributor for any apparent contraventions. The Clerk's report has outlined an apparent contravention of the Act by the contributor. Neither this committee nor any auditor before the committee today has any power to determine whether a contravention of the Act has in fact occurred. That duty is left entirely to a court. The contributor or his counsel, or both, may make submissions to the committee on today's item if they wish. Once any speakers have spoken, committee members may ask them or city staff questions or speak to the matter. The committee will then recess the meeting to deliberate in private. It will then reconvene to issue a decision by motion. If the committee decides to commence legal proceedings, the city clerk will work with the city solicitor to carry out the required steps to implement the committee's decision, including the retention of an independent prosecutor. Once the prosecutor is retained, if that is the decision of the committee, the prosecutor will review the records relating to this matter with a view to being able to make an informed exercise of the prosecutor's discretion on whether or not to pursue the prosecution. Mr. Duchesne's law firm is the committee's normal independent counsel, has requested that the committee provide its consent to him excusing himself from consideration of these contributors' reports, as his firm represents one of the contributors. The committee has agreed to that consent and retained alternative independent legal counsel who are available on request. I trust that everyone who wishes to speak today has filled out a request to speak form and has submitted it to the coordinator. Let us begin then with the first item on the agenda, being the city clerk's report in respect to a contributor to candidates in the 2018 regular election, Mr. John Riddell. We currently have the following list of speakers on this item. Mr. Roberto Aburto from Gowling, on behalf of John Riddell, and someone, a second person, Kevin O'Donnell, has also requested permission to speak on this matter. The committee will deal with that request after we've heard from Mr. Alberto. We have discretion to hear from Mr. O'Donnell if it's the committee's wish that we do so. Mr. Alberto, would you like to speak for your client, to Mr. Riddell, on this matter?
Yes, thank you. Good afternoon. So again, my name is Roberto Aburto from Gowling WLG, legal counsel for Mr. Riddell. And Mr. Riddell is in attendance here today. He's provided written submissions, which I understand that you're already in receipt of.
That's correct.
And we're reiterating, not introducing anything new today. It's sort of a reiteration and clarification of those submissions, asking that the committee not exercise its discretion to commence proceedings against Mr. Riddell. Mr. Riddell was not aware of the $5,000 limit, and if he were aware, he would have complied with it. And while the provisions of the Municipal Election Act provide that this is a strict liability offense, so meaning from a legal perspective, the person's intentions is not considered at first instance, that intention is considered and is important context when a court considers whether or not the contributor exercised due diligence. So said in another way, in a prosecution, the court will ask itself whether Mr. Riddell acted reasonably. And to inform reasonable actions, we submit that the court would consider the context, which includes the obligations of the candidates. Section 88.221R of the Municipal Elections Act requires that candidates inform potential contributors of the limits, including that $5,000 total limit, and Mr. Riddell received solicitation emails. 4 of those emails themselves did not reference the $5,000 limit. For the 5th contribution, Mr. Riddell does not recall specifically. It was likely a telephone conversation that led to that, and wasn't able to find any emails in relation to say. But in responding to this matter, with full disclosure, Mr. Riddell did become aware that one of the PDF attachments from Mr. Watson's campaign did reference that limit, but Mr. Riddell doesn't recall looking at that PDF, and just it was a mistake and he wasn't aware of it. He did comply with the $1,200 per candidate limit because he was aware of it, and I would suggest that that goes to the credibility of saying that if he was really disregarding it, why would he comply with the $1,200 but not comply with the $5,000? And further, we submit that it's not in the public interest to commence proceedings against Mr. Riddell. This matter has already attracted media attention, and Mr. Riddell has accrued legal fees. In terms of the objectives of deterrence, that objective has already been achieved. Mr. Riddell will not do this again. The total over-contribution of $1,000 we submit does not warrant commencing a prosecution, and accordingly we request that the committee not move forward with the prosecution.
Thank you. Do committee members have any questions of Mr. Riddell's counsel? Mr. Riddell, I hope I'm pronouncing your name correct. Is it Riddell?
Riddle.
Riddle, thank you. I'm sorry for previously mispronouncing it. Do you wish to add anything to the comments made by your solicitor?
No, I'm happy to answer questions.
Okay. Member Bergeron, have you any questions of either Mr. Alberto or Mr. Riddle?
I do. This is to the clerk's office first. Can you confirm for me that for 2018 election, it was the first election where only individuals could contribute?
That's correct, Mr. Chair.
Okay, and the contribution limits, just reconfirm those again, please.
Mr. Chair, the Municipal Elections Act sets out two contribution limits, $1,200 to a single candidate and $5,000 to multiple candidates for the same council.
Okay, and when was this $5,000 limit established under the MEA?
The $5,000 limit to multiple candidates was established in 2009 through amending legislation entitled the Good Government Act, or what was then called Bill 212. So this would be the third cycle, Mr. Chair.
Thank you. So I have a couple of questions just of the contributor. Was 2018 the first time you ever contributed to a campaign?
No.
So,
I had contributed previously.
okay. And you were never aware since 2009 that there was a $5,000 limit?
No, I wasn't.
Okay.
Thank you. Vice Chair, do you have any questions? Member Wang? I understand, Mr. Cox, that although the $5,000 maximum contribution to an aggregate of two or more candidates was in the act previously, was there a new aspect to the legislation this year with respect to the city solicitor's reports to this committee?
Yes, Mr. Chair. Bill 181, the Municipal Election Modernization Act in 2016 amended the Municipal Elections Act and introduced this new requirement that the clerk report on any apparent instances where a contributor appeared to have contributed more than the $1,200 or $5,000 limits.
Okay, so this was the first time that this committee or its predecessor saw reports dealing with contributions to more than two candidates.
That's right, Mr. Chair.
Thank you. Do members have any wish to make any statements before we go in camera to deliberate our decision?
Is another speaker?
Yes.
There's another speaker. There's another speaker.
No, nobody wishes to speak further. Members, right? Thank you very much.
Thank you.
Mr. O'Donnell, would you like to speak to this matter?
Thank you for this opportunity. I'm just here to speak to my points of view on the merits of the public interest of having this committee recommend this particular matter for prosecution. I'm essentially arguing the inverse of the previous comments. Money is power, and Mr. Riddle's over-contributions violated the equality of opportunity for election candidates in 4 different wards and for the mayor's race. Mr. Riddle likely gave one too many $1,200 checks. It seemed he had a desire to contribute the maximum to each candidate, which is entirely valid, and produced one additional check. We can't blame the candidates for that, but unfortunately they were given an unfair advantage over their competitors in the process that decides who is going to run our city, one of the most important decisions that happens relating to the place we're in right now. The overcontribution to Mr. Kadri was 8.8% of his rival's entire budget. It was similarly 6.5% of the harder campaign's rival's budget. In Ward 2, it was 7% of the rival's budget. And finally, the contribution to Mr. El Shantiri was 10% of the rival's budget. These are significant disturbances in the sanctity, fairness, and integrity of our democratic process. How many ads in local papers were the preferred candidates able to purchase with additional funds that they were given beyond the limits? What effect might those additional ads have had in the outcome? The list of questions goes on, and unfortunately those questions are unanswerable. We cannot know how the process was disturbed by the overcontributions. So I'm glad the Ontario law was changed, requiring the clerk to produce the report that's before you today. But that is only one half of the corrective measures that the Ontario government chose to put in place. The other half of those corrective measures is this body proceeding on the very clear, apparent overcontributions. I understand that's not a guilty finding or anything, because the other half of the process needs to be engaged in order to fully cleanse and protect the democratic process that this body is charged with overseeing. As mentioned by the chair at the beginning, this committee is not the body that is charged with accepting apologies or accepting admissions of guilt, which I air quoted in my notes. This body simply can't make that finding. That's why this body is charged with, dealing with administrative errors, as we saw at the previous meeting, errors in paperwork that make an apparent overcontribution with a little bit of review become not overcontributions after we can see some paperwork. That's an improvement. In this case, it's very clear that there are no such, accidental things happening. This is a clear breach of the law, as the council mentioned, that the intent does not matter, and this body, I believe, must proceed. The correct body to accept admissions of guilt or make those public interest findings about what should happen in this case is a prosecutor who can negotiate with a defendant, come to that finding, make a sworn statement with a sworn admission of guilt, and that is the intended outcome of the law that the Ontario government put in place. So I encourage this committee to proceed as needed. Thank you very much.
Thank you, Mr. O'Donnell. Do members have any questions of Mr. O'Donnell? Or do the members wish to make any statement at this time? Then is it the committee's wish to proceed in camera to deliberations? All members agreeing that's what we'll do. Thank you.